Some stories don't end when the verdict is read. Some stories keep echoing long after the courtroom lights fade, long after the evidence is boxed up, long after the monster at the center of it all is led away in chains. For most families, a guilty verdict is the final chapter. For the Kimmells, it was only the beginning of another battle. Because in Wyoming, justice doesn't always stay settled. Not when the system bends. Not when a killer becomes a symbol. Not when years of legal wrangling threaten to pull a case back into the darkness it fought so hard to escape. This is the part of the story where answers start to unravel. Where the death sentence handed to Dale Wayne Eaton, the man who kidnapped, assaulted, murdered, and buried 18-year-old Lisa Marie Kimmell, didn't hold the way everyone thought that it would. Where appeals, reversals, and constitutional challenges turned a supposedly closed chapter into a new wave of uncertainty. And while the courts argued over technicalities, another question started growing louder across the Great Basin. Was Lisa his only victim? Because the more investigators learned about Eaton, his property, his past, his behavior, the harder that question became to ignore. Disappearances, unsolved cases, women who vanished on highways he traveled, stories whispered in the shadows of Fremont, Sweetwater, Natrona, and Carbon counties. Stories that sounded too familiar, too similar, too close. Rumors, patterns, possibilities that make your stomach drop. And through all of it, through the trials, the reversals, the rumors, and the smoke, one truth stayed solid. Lisa Marie Kimmell changed Wyoming. Her case reshaped how the state handled major crimes. It reshaped forensic procedure. It reshaped interagency cooperation. It reshaped how missing women were investigated and how law enforcement listened when families begged for help. Her story didn't just alter one community, it altered an entire system. Tonight, we step into the echoes, the legal battles that refuse to die, the rumors that still haunt the High Plains, and the legacy of a young woman whose name, Lil Miss, still carries weight in every sheriff's office, evidence locker, and cold case file from Cheyenne to the Montana line. This is the part where the road doesn't end. It widens, it branches, it forces us to ask questions some people in Wyoming still don't want to answer. This is Dark Dialogue Rocky Mountain. Oh, hey Angela. How's it going today?
It's okay. How are you?
I'm good.
A little ahead of yourself there?
A little bit ahead of myself there, yeah.
That's all right. You put the brakes on. Brake check, it worked.
So, how's it going?
It is going.
Yeah?
I dare not put an action
Nothing more than that.
to it. It's just going.
It's going. Well, I guess that's better than the alternative.
This is true.
Yeah.
This is well, most of the time, this is true.
Yeah. So, you ready to do the final?
On Dale Wayne Eaton some more?
Yeah.
Always.
And the final chapter of Lisa's story.
It is.
It is.
The final chapter.
All right, listeners, this is Dark Dialogue Rocky Mountain Reckoning, the series where we return to the crimes rooted deep in the dirt, dust, and the desolation of the American West. The stories that shaped small towns, broke families, and carved their way into Wyoming history, whether anyone was ready or not.
We investigate the cases buried under snowfall, sagebrush, and decades of silence. The ones whispered through the fence lines, across empty highways, and in the kind of places where the horizon feels endless. But secrets don't stay buried.
Tonight, we're looking at what came after Dale Wayne Eaton's conviction, the unraveling of his death sentence, the long, exhausting legal battles that followed, and the rumors that linked him to other disappearances across the Great Basin. Because when a man builds a graveyard under his own land, people start asking what else he left behind.
We'll also talk about Lisa's legacy, how one young woman changed the way Wyoming investigates violent crimes, processes evidence, and chases predators who hunt along rural roads. Her case didn't just inspire reform, it demanded it.
Before we dig into the echoes of this case, do us a huge favor. If you're listening on YouTube, hit that thumbs up, subscribe, and ring that bell so you'll never miss an episode.
And if you're on Spotify, Apple Podcasts, Amazon, or anywhere else you get your shows, follow the podcast, rate the show, and leave us a review. Those reviews help more than you know, and they push these stories into the spotlight where victims' names can't be forgotten.
Share the episode with a friend, post it on your socials, or send it to someone who remembers the Little Miss case. Every share keeps these stories alive and helps us keep digging.
This is episode 7, Echoes of the Forgotten.
And this is Dark Dialogue, Rocky Mountain Reckoning. The gavel had barely stopped echoing when the state of Wyoming moved to make sure justice stayed anchored in place. In May of 2004, during the formal sentencing hearing, the court did something rare, something that spoke louder than any headline. Judge David Park handed down the death sentence, but then he added something else, a life sentence, stacked beneath it like a foundation. A safeguard, a message, insurance against the possibility that higher courts, with their technicalities, challenges, and constitutional debates, might one day try to loosen the noose around Dale Wayne Eaton's neck. It wasn't done out of uncertainty. It was done out of experience, because in Wyoming, the death penalty isn't just a sentence. It's a promise constantly under attack. And Judge Park knew the legal storms that would follow. So Eaton left the courtroom with death above him, life beneath him, and the weight of 2 judgments pressing down on his future. But justice, as everyone would learn, never stays still for long. As the months passed, the courtroom quieted, the headlines slowed, and Casper finally exhaled, believing the case was settled, believing Eaton would spend the rest of his days under the sentence that he deserved. But behind the scenes, another machine had already started moving. Lawyers, filings, petitions, challenges to procedure, representation, mitigation, and the very structure of the trial itself. By April 2005, the first tremors began. By June, they were impossible to ignore. The man who murdered Lisa Marie Kimmell was no longer just an inmate. He'd become an appellant, a defendant again. And the long, grinding gears of post-conviction review were suddenly turning in his favor. This is where the cracks begin. This is where certainty starts to bend. And this is where Eaton's legal war truly begins. By the spring of 2005, the courtroom that had delivered justice for Lisa Marie Kimmell only a year earlier opened its doors once more. Not to retry the evidence, not to question the jury, but to put the defense attorney himself under the microscope. This is the part of the death penalty case most people never see. The headlines fade, the TV cameras go home, and the story leaves the public stage and moves into a quieter, more technical arena, the post-conviction review. What happened between April and June of 2005 wasn't dramatic, it wasn't emotional, but it was crucial, because the question wasn't whether Dale Wayne Eaton murdered Lisa. It was whether his trial attorney, Wyatt Skaggs, had done his job well enough to allow the verdict to stand. This process has a name in Wyoming, a Killeen remand, born from State versus Killeen and required in every state death sentence. It's the legal system's way of saying, before we take a man's life, we check our work. The 7th District Court in Natrona County convened multiple days of hearings, gathering written filings, oral arguments, deposition transcripts, expert testimony, and the voices of the very people who had shaped the 2004 trial. At the center of it all sat Wyatt Skaggs, the man who had defended Eaton in the original courtroom. He was sworn in, seated, and asked to explain every strategic choice that he made, including the most controversial detail of all. Why did he concede Eaton's guilt during closing arguments? That single decision became the heartbeat of the defense's post-conviction attack. Skaggs told the court that he had told his team during the trial that evidence against Eaton was overwhelming. DNA, the buried car, the timeline, the behavior, the property. There was no reasonable way to argue innocence. So Skaggs chose a different path. Admit the undeniable. Shift the battle from guilt to life. Fight to spare Eaton from the death penalty instead of wasting credibility denying reality. It was a tactic some attorneys have used under Strickland versus Washington, the U.S. Supreme Court standard that governs ineffective assistance claims nationwide. But it's a tactic that courts examine with surgical precision. Eaton's post-conviction attorney argued that Skaggs had failed him in several critical areas. He didn't investigate Eaton's abusive upbringing deeply enough. He missed opportunities to document potential mental health impairments. He failed to present a broader story of mitigation. He surrendered guilt without Eaton's fully informed consent. And he didn't challenge certain jurors or pretrial motions aggressively enough. Every one of these arguments was backed by case law, expert declarations, and thick binders of analysis. But Skaggs countered with his own rationale. He did investigate Eaton's past, and what he found wasn't consistent, verifiable, or compelling enough to override the brutality of the crime. He did explore mental health, and no expert found a diagnosis that would mitigate the murder. He did present evidence of abuse, and the jury heard it. He did tell Eaton the strategy, even if Eaton didn't like it. The judge listened, reviewed every transcript from the original trial, evaluated new exhibits, and took weeks to analyze whether Skaggs had crossed the line from strategy into incompetence. By June 2005, the court issued its ruling. Wyatt Skaggs may have taken an unconventional path, but he did not violate the Constitution. His concession of guilt was deemed a tactical choice, grounded in overwhelming evidence, consistent with established defense strategy, and not a betrayal of Eaton's rights. The court held that Eaton received a fundamentally fair trial. The motion for post-conviction relief was denied. The death sentence and additional life sentence remained intact. For the Kimmell family, it was one more affirmation that the system still held. For Eaton, it was the first major loss in a long appellate war. And for the legal community, it was business as usual. Another capital case passing through the routine but vital machinery of post-conviction review. But here's the part no one realized at the time. These hearings, the paperwork, the testimony, the arguments, became the foundation for the federal habeas battles still to come. Battles that would eventually, years later, pull apart the very sentence the state had fought to protect. In capital litigation, post-conviction review isn't just a safeguard, it's a roadmap. And in April to June 2005, the first markings on that map were drawn, quietly, methodically, and with consequences Wyoming wouldn't feel until much later. By the time September of 2006 arrived, the Kimmell case had already survived a trial, a sentencing, a clean remand, and a year of legal maneuvering. But now the fight had climbed to the highest courtroom in the state, the Wyoming Supreme Court in Cheyenne. It was here, on September the 14th, 2006, that Dale Wayne Eaton's attorneys stood before 5 justices and made their most ambitious argument yet, that the entire capital trial, from jury selection to sentencing, had been poisoned by ineffective counsel, bad instructions, and fundamental unfairness. This wasn't just another hearing. This was the moment Eaton's team threw everything they had at the wall, hoping something, anything, would stick. And they didn't come lightly. His attorneys arrived armed with thousands of pages of briefs, appendices, supplemental filings, and constitutional challenges that dissected nearly every minute of the 2004 proceedings. It was, in many ways, a full-scale attack on the entire structure of the original trial. Eaton's attorneys pressed a line of argument built on 2 pillars. 1, his lawyers failed him, and 2, the jury was never properly guided. Everything else, mitigation, mental health, voir dire, venue, procedural objections, even Eaton's own competence, flowed from those 2 claims. The justices listened as Eaton's appellate team argued that trial attorneys Wyatt Skaggs and his colleagues had failed to investigate Eaton's abusive childhood deeply enough, failed to meaningfully develop potential mental health mitigation, failed to challenge problematic jurors, failed to object to flawed instructions, and most controversially, conceded Eaton's guilt without his informed, explicit consent. And I just got to say here, this shit pisses me off. Like, I'm sorry, you decide to kidnap a woman, hold her hostage for days, torture her, rape her, murder her, and throw her in a river? I could give a two shits about your childhood. I really don't care. That gives no excuse whatsoever.
None.
And this whole concept of mental capacity and legally sane in it, I don't give two shits. I don't care. Now, is there an argument to be made that if somebody is insane, that they need to be locked away in a mental home instead of a prison?
Yeah.
Okay, fine. I don't give a shit, but they still need to be locked away for the rest of their damn lives.
Yeah.
I cannot get behind this. You're too insane, so we turn you out so you can do it again shit.
Right.
It's insane to me. So that just gets me on my soapbox a little bit because I don't give a shit what excuse you make for killing people. There's no excuse for killing people.
Right.
And so does it mean we don't kill him? No, we still kill him.
Yeah.
But that's my opinion. And this son of a bitch, there's no way that he was incompetent. He was ruled competent time and time again.
Yeah.
Yeah, he should have died. Anyway,
He's
sorry.
not there long enough to be incompetent.
Right. But that's the other problem I have with the death penalty. We wait until somebody's too freaking geriatric to know what in the hell they're doing. And then we say no, we can't kill them now. Well, that's why you kill them the day after the freaking trial's done.
Yeah.
So you don't have to do with this shit anymore. Sorry.
So now we know how John feels.
Yeah. Especially when it comes to this guy, because you know how I feel
You're
about
right,
him.
dude. I have a feeling if they actually ever do death sentence him and follow through, you're going to be there.
Oh, they never will. It's that ship sailed. You'll see that by the end of this episode. It's done.
Oh, okay.
He'll die in prison, a vegetable, and probably not too far from now because he's in bad shape, but we'll get to all that.
Okay.
The concession argument was the flashpoint. For Eaton's lawyers, it was the smoking gun. The decision that, in their eyes, doomed the defense before the sentencing phase even began. But for the state, it was common sense. With DNA, with the buried car, with every piece of evidence pointing directly at Eaton, the defense had no realistic path to acquittal. Still, the justices had to decide whether Skaggs' choice had crossed the constitutional line. Eaton's team also argued that the jury never received clear, accurate directions on aggravating factors, mitigating factors, the burden of proof in capital sentencing, the weighing process, and the meaning of the key statutory terms. But the boldest challenge was this, that the court had used statutory amendments passed after Lisa's murder when instructing the jury, a move Eaton's lawyers said violated the ex post facto clause and stacked the deck against the defense. In truth, that alone could have unraveled the entire death sentence. Eaton's lawyers also pushed the idea that he was not competent at trial. His behavior showed mental instability. The court should have ordered psychiatric evaluation. Juror misconduct allegations were mishandled. Voir dire errors allowed biased jurors. The trial court showed subtle but damaging bias. Almost every major element of the case had been pulled apart, reframed, and reintroduced under a microscope. The Wyoming Attorney General's office did not waver. Their argument was simple and unshakable. The trial was fair, the evidence was overwhelming, and nothing Eaton's attorney alleged came close to a reversible error. They reminded the justices on the mountains of proof, DNA linking Eaton directly to Lisa, the buried Honda CRX, the neighbor's journal documenting his digging, the timeline, the violence, the pattern, the intent. They argued that no instruction, no missed objection, no mitigation detail, no strategic disagreement would have changed the jury's decision because the truth was simply too strong to ignore. In their view, The defense was relitigating the case not because it was flawed, but because they had nothing left to lose. After nearly an hour of oral argument, the justices took the case under advisement. There would be no immediate decision, no dramatic reversal, just silence and waiting. For almost 2 years, the opinion remained pending. Then, in August 2008, the ruling finally came down. The Wyoming Supreme Court rejected every claim, every issue, every objection, every allegation of incompetence or unfairness, every challenge to jury instructions, every argument about consent, venue, mitigation, or statutory error. They upheld the conviction, they upheld the death sentence, they upheld every finding of the district court. For Lisa's family, it was one more affirmation, another year where the truth held firm. But the legal battle didn't end there. It simply shifted arenas because the September 2006 appeal, though unsuccessful, created the detailed record that federal judges would later pore over, line by line, until they found something the Wyoming courts had missed. This was the appeal that failed, but it was also the appeal that cracked the door that would eventually break the death sentence apart. By late summer of 2008, the long arc of state-level review in the Kimmell case had finally reached its end. For 2 years, the Wyoming Supreme Court had been poring over transcripts, arguments, filings, exhibits, motions, affidavits, and every word spoken during the capital trial of Dale Wayne Eaton. Everything the defense had thrown at the wall in their 2006 appeal, every challenge, every accusation, every alleged flaw, now sat in the hands of the 5 justices who would decide whether the verdict would stand or crack. And on August 19, 2008, the court delivered its answer. It came in the form of a lengthy, meticulously written opinion, an opinion that did not hesitate, waver, or hedge. The Wyoming Supreme Court fully affirmed Eaton's conviction and upheld his death sentence. This was the moment the state declared unequivocally that the trial of Dale Wayne Eaton had been fair, constitutional, and just. Eaton's attorneys had come into the appeal with an armory of arguments, a sprawling, exhaustive list of everything they believed had gone wrong in 2004. The justices addressed each claim, methodically dismantling them one by one. Ineffective assistance of counsel. The court rejected every allegation of attorney failure. They found that the investigation in Eaton's past was reasonable, mental health exploration was adequate, mitigation decisions were strategic, the concession of guilt was, given the overwhelming evidence, an acceptable tactical choice, and the defense team's overall performance met constitutional standards. There was no Sixth Amendment violation, no breakdown in representation, no basis to question the trial's integrity. Improper jury instructions. Eaton's team had attacked the instructions on aggravators, mitigators, sentencing standards, and even the statutory language used at trial. The court found no misleading language, no misuse of post-crime statutory amendments, no ex post facto violation, and no instructional flaw that could have influenced the outcome. The instructions they held accurately conveyed Wyoming law. Procedural and juror misconduct. Eaton's lawyers argued the prosecution overreached. Improper statements tainted deliberations, and a juror allegedly conducted outside research. The court acknowledged the claims and then rejected them. They ruled there was no prejudicial misconduct that occurred. No juror behavior rose to the level of constitutional harm, and the integrity of the deliberations remained intact. Courtroom bias and competency claims. The justices found no evidence, none, that Eaton was incompetent during trial, nor that the judge acted with hostility or prejudice that compromised fairness. Cumulative error. Finally, Eaton's attorneys fell back on the catch-all. If no single error warrants reversal, maybe all of them together do. The court had a simple answer: no. Even if minor mistakes occurred, none came close to undermining the validity of the verdict. There was no cumulative error. There was no fundamental unfairness. The conviction and sentence remained sound. The ruling of Eaton versus State of Wyoming, 2008, Wyoming 133, closed the book on Eaton's direct appeals in Wyoming. This was final. The state courts were done. Every issue available under Wyoming law had been exhausted. For Lisa's family, this was another moment of affirmation, another official recognition of truth. The state had reviewed everything, questioned everything, reevaluated everything, and still found the verdict unshakable. But behind the scenes, Eaton's attorneys were already preparing for the next battlefield, the federal courts. And the very record the Wyoming Supreme Court used to uphold his sentence would soon be used to attack it again, with far different results. What happened on August 19, 2008 wasn't just a conclusion. It was a hinge. The moment the case transitioned from Wyoming's authority to the broader, more unpredictable world of federal habeas review. Eaton's fight wasn't over. It was only changing shape. And you know what blows my freaking mind about this?
Tell me.
This all happened when I was 11 years old.
Mm-hmm.
And these trials are occurring at the time that my youngest was born.
Yeah.
I already had 3 kids,
Yeah.
now 4 kids. I mean,
Finally.
it is insane how long this shit drags on.
Yeah,
It's inexcusable,
definitely.
because you got to think about what the family's going through for freaking like 40 damn years.
And can you imagine if it would have broke open during COVID? It'd be even longer.
That's no shit. Didn't miss it by much.
Not by much, but
By the fall of 2008, Wyoming believed it had reached the end of the line with Dale Wayne Eaton. The state's highest court had upheld every ruling, the conviction, the sentencing, the procedures, the instructions, all of it affirmed with absolute finality on August 19, 2008. And under Wyoming law, once the direct appeals are exhausted, the clock begins to move toward one final step. The governor sets a date. For Eaton, that date was December 19, 2008. A formal execution warrant had been signed. The state prepared for the only capital punishment scheduled in decades, and the Kimmell family braced themselves for a moment that they had waited nearly 20 years to see. But the legal system never walks in a straight line, especially when a life hangs in the balance. And on October 28, 2008, the path shifted again. Less than 2 months before the scheduled execution, Eaton's attorneys filed a sweeping, urgent motion with the Wyoming Supreme Court. It wasn't subtle. It wasn't procedural fluff. It was the legal equivalent of slamming a hand on the brake pedal. They argued that Eaton's federal habeas corpus rights had not yet been exercised, that multiple constitutional issues were still unresolved, that ineffective assistance claims deserve full federal scrutiny, that competency questions remained untested, and that executing Eaton before federal review would violate the most basic protections afforded to every capital defendant in the country. This wasn't a plea for mercy. It was a demand for due process, a requirement so deeply rooted in American law that even the strongest death sentence cannot leapfrog it. The message was clear. You cannot kill him until the federal courts have their say, and the justices knew the attorneys were right. On November 15th, the Wyoming Supreme Court issued its ruling. They did not revisit the evidence. They did not question the jury. They did not amend their August decision. Instead, they did what the system requires. They stayed the execution, halting the December 19th date and freezing any attempt to carry out the sentence until Eaton's federal habeas review could begin. This wasn't an act of mercy. It wasn't a sign of doubt. It wasn't a reflection of weakness in the state's case. It was procedure, the guardrail built into every capital case, the guarantee that before the state exercises its ultimate power, the federal judiciary has the opportunity to check for constitutional errors. In Wyoming, as in every death penalty jurisdiction, it's non-negotiable. The state ensured that Eaton could file his federal habeas petition. All constitutional claims could be heard. Mental health and competency arguments could be reviewed. Ineffective assistance claims could be analyzed under federal standards, and no irreversible action could occur until every avenue had been exhausted. The December execution date evaporated, replaced by a legal process that would stretch on for years. For the Kimmell family, it was another moment of waiting, another delay, another reminder that justice, once again, moves only as fast as the slowest piece of the system. But this stay was also the doorway to the next chapter, the federal fight, the long, technical, grinding battle that would eventually reshape the entire case. This was the moment that the state stepped back and the federal court stepped in. The execution never happened in 2008, and because of what the federal judges would later uncover, it would never happen at all. By early 2009, the battle lines in the Kimmell case had shifted once again. The Wyoming Supreme Court had affirmed the conviction, it had affirmed the death sentence, it had rejected every claim, motion, and challenge thrown at it in 2008. And yet, even with all the state-level doors closed, the legal machinery surrounding Dale Wayne Eaton still refused to stay silent. Because 2009 became the year the system pressed pause, not because Eaton had found a crack in the ruling, but because capital punishment, by design, moves only as fast as the slowest appeal. And that year, the appeals came fast, loud, and nonstop. The Wyoming Supreme Court issued a simple, powerful order. Eaton's execution would remain on hold. No ceremony, no explanation beyond what the law already demands, until every remaining appeal, challenge, and petition had been reviewed. The state could not move forward with an execution date. This wasn't about doubt. It wasn't about mercy. It was about due process, the constitutional guardrail built into every death penalty case. And for the Kimmell family, it meant more waiting. Just when it seemed the path was set, Eaton's attorneys filed another appeal with the Wyoming Supreme Court. This time, they argued that the court had failed to adequately address constitutional issues. Prior decisions were too narrow, and key claims, particularly ineffective counsel and due process violations, deserve deeper review. It wasn't a new argument, it was a reframing, a last attempt to convince the state's highest court that something had been overlooked. The justices accepted the filing procedurally, but they weren't opening the door to a new trial. This was an administrative cleanup, another stone that needed turning before the federal review could begin. In mid-October, the district judge issued a decisive ruling. Appeal denied. The court found the case had been reviewed thoroughly. The Wyoming Supreme Court had followed constitutional precedent, and the latest claims did not warrant any further action. It was a blunt message. The state had done its job. There is nothing left to revisit here. But Eaton's attorneys weren't finished. On Thanksgiving Day, while families across Wyoming gathered around dinner tables, the Wyoming Supreme Court issued one more ruling. Eaton's newest petition, another attempt to delay or reconsider, was denied. That was it. Every state avenue had now been exhausted. There were no more backdoors, no more procedural footholds, no more state-level motions left to file. The only path remaining was federal, and that path would open far sooner than anyone expected. After the last state petition was denied, a district judge set a new execution date for February 2010. But before Wyoming could move forward, before the Department of Corrections could prepare the chamber, before the Kimmell family could brace themselves yet again, the U.S. District Court intervened. On December the 18th, the federal judge issued a stay of execution, halting everything until Eaton's federal habeas corpus petition could be fully reviewed. This wasn't unusual. In fact, it was required. Federal law guarantees every death row inmate the right to challenge constitutional violations, present new evidence, argue ineffective counsel under federal standards, raise competency concerns, and question whether the state's process met the strict requirements of capital punishment procedure. And the federal court made it clear, Wyoming would not execute Dale Wayne Eaton until the federal judiciary had examined every claim, no matter how long it took. For the Kimmell family, the promise of resolution slipped out of reach once more. For Eaton, the clock was reset. And for the case itself, 2009 marked the beginning of a long, grinding federal war that would reshape everything. This was the year the execution date dissolved into legal fog, the year the states stepped back and the federal courts stepped forward, and the year that, without anyone realizing it yet, the road to overturning Eaton's death sentence truly began. By the summer of 2010, the battle over the fate of Dale Wayne Eaton had officially crossed the state line, not geographically, but jurisdictionally. Wyoming had done everything it could. Every appeal, every remand, every procedural safeguard, every claim of constitutional error had been weighed and denied. But under American law, a death sentence isn't final until the federal courts have walked the same path. And on August the 21st, 2010, Eaton's attorneys took the biggest step of his post-conviction life. They filed a 300-page federal habeas petition, the kind of document that signals not just a continuation of the fight, but a full-scale legal war. This was not the appeal of a man hoping for a technicality. This was an appeal of a man who knew the only thing standing between him and the execution chamber was the deepest, most exhaustive constitutional review available in the United States. The petition was brought under 28 U.S.C. 2254, the federal statute that allows prisoners to challenge state convictions on constitutional grounds after the state courts have had their say. It was dense, aggressive, and sprawling, a document designed to leave no stone unturned, no angle unexplored, no procedural opportunity unused. Eaton's attorneys argued that nearly every part of his trial had gone wrong. Ineffective assistance of counsel. They attacked his representation from both the guilt and penalty phases, the failure to investigate Eaton's family, all the same old bullshit. I ain't gonna read it all. It's all the same over and over again. It was the same claim that they had raised before, but now reframed for federal standards, jury instruction errors. Again, same bullshit. And they added one constitutional twist, that the state had used amended sentencing language passed after Lisa's murder, an alleged ex post facto violation under the U.S. Constitution. They claimed the trial court failed to properly evaluate Eaton's competence to stand trial, and that counsel was ineffective for not demanding a full mental health evaluation, blah, 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 blah. They also said that the jurors screwed up they also said that his attorney was a dipshit and didn't do anything right, his ineffectiveness of counsel. And they again raised the allegation that one or more jurors conducted independent research, which is a direct constitutional violation if proven. They also argued again for the cumulative error. Even if no single issue warranted reversal, they argued the combined weight of all the errors made the sentence unreliable. This was not a petition designed to throw one lifeline. It was a petition designed to throw 20 and dare the federal courts to grab one. The Wyoming Attorney General's office responded swiftly and forcibly. Their argument was simple. The state courts got it right. Every claim has already been reviewed, and the federal laws don't allow do-overs just because the defendant doesn't like the result. They invoked the AEDPA standard, the exceedingly high bar that federal courts must use when reviewing state convictions. Under AEDPA, a state ruling can only be overturned if it was contrary to federal precedent or an unreasonable application of it. The AG argued the record showed no incompetence, mitigation had been reasonably explored, the concession of guilt was strategic and constitutional, the jury was properly instructed, and no prosecutorial or juror misconduct rose to the level of violating due process. And they reminded the court this was not a close case. This was a case built on DNA, forensic certainty, a buried car, timelines, and a piece of shit who hid the evidence on his own land. The filing of the habeas petition triggered what would become a multi-year federal review, one that stretched from the U.S. District Court to the 10th Circuit Court of Appeals and eventually to the brink of the U.S. Supreme Court. This petition, these 300 pages, became the foundation for everything that happened next, because buried inside those hundreds of pages were claims that would eventually convince a federal judge that the sentencing phase of Eaton's trial had crossed a constitutional line. Not immediately, not quickly, not without resistance, but in federal court, time works differently. Slow, technical, deliberate. And it was here, in a federal courtroom far removed from the Wyoming landscapes where Lisa's case had unfolded, that Eaton began the long march toward the ruling that would upend his death sentence in 2014. This was the moment the federal war began, and it would not end quietly. By 2011, legal battle over the fate of this piece of shit had entered its slowest and most technical phase, a world of sealed filings, dense motions, and years-long timelines. Federal habeas review is not fast, it's not dramatic, and it rarely appears in the headlines. But it is where death sentences either survive or fall apart. And for Eaton, 2011 became the year his attorney dug deeper, sharpening arguments, expanding claims, and laying the groundwork for the bombshell ruling that would come 3 years later. In March 2011, Eaton's defense team filed a new set of motions with the U.S. District Court, supplements to its massive 300-page petition that they'd submitted the year before. These were not casual filings. These were highly calibrated legal missiles designed to widen the cracks in Eaton's death sentence and push federal judges toward one conclusion. The sentencing phase of the 2004 trial was constitutionally defective, ineffective assistance at sentencing. The attorneys argued that Eaton's team failed to investigate his background, overlooked his mental shit, blah, 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 all the same bullshit. The state pushes back. The attorney general's office didn't flinch. They argued every claim had been reviewed. They argued all the same shit that they'd already argued. But the filings in 2011 didn't resolve anything. No rulings came, no hearings were held, no decisions were announced. But these motions set the stage for what would come next, because in capital habeas litigation, the groundwork matters. You don't win with one argument. You win by building a mountain the judge can't ignore. And Eaton's attorneys were doing exactly that. These filings laid the foundation for the 2013 evidentiary hearings, the moment when the federal court would finally pull the curtain back and ask whether Eaton's sentencing phase had been constitutionally sound. Those hearings would change everything. And years from now, when Judge Alan B. Johnson overturned Eaton's death sentence, he would point back to the issues raised in 2011. The mental health evidence, the missing mitigation story, the failures of counsel, and the reasons the death sentence could not stand. 2011 wasn't the climax. It was the quiet before the storm, the tightening of the screws, the subtle shift in the ground beneath the case. This was the year the federal war began to turn. By the time 2013 arrived, the legal battle over Dale Wayne Eaton's life had stretched across nearly a decade. Appeals, remands, petitions, stays, every procedural step had been taken. Every state-level argument exhausted, and still the question remained: did the state of Wyoming obtain Eaton's death sentence constitutionally? The question is the razor's edge of death penalty law, and in the spring and summer of 2013, the entire case would finally be put under a federal microscope. In May 2013, Eaton's attorneys filed what would become the most important document in the entire post-conviction saga, a comprehensive federal habeas corpus petition, the culmination of years of filings, hearings, and legal groundwork. It was enormous, hundreds of pages, thousands of citations, a point-by-point assault on the integrity of the original trial, and especially the sentencing phase. The core argument was ineffective counsel. The petition laid out a brutal portrait of the defense Eaton received back in 2004. That trial counsel never properly investigated Eaton's life history, never uncovered or presented critical mental health evidence, never told the jury about the childhood trauma that shaped him, and never built the comprehensive mitigation required in capital trials. The claim wasn't subtle. If the jury had known that truth, at least one juror would have voted for life instead of death. But the petition didn't stop there. It challenged flawed jury instructions, prosecutorial misconduct, juror research and outside influence, competency issues, inadequate voir dire, and the cumulative effect of errors that, taken together, undermined the fairness of the sentencing. The defense also raised a powerful procedural problem. After so many years, key mitigation witnesses had died or disappeared. If a new sentencing trial were ordered, they argued, it couldn't be conducted fairly anymore, making life without parole the only viable option. This was not a petition designed to tweak the record. It was designed to crack it open. On July 30th, 2013, the case finally entered its decisive moment. U.S. District Judge Alan B. Johnson opened an extraordinary evidentiary hearing in Cheyenne, a hearing that would run for days and pull apart nearly every aspect of the 2004 sentencing. What made this hearing different? Most federal habeas cases are decided on the written record. No witnesses, no testimony, no second chances. But not this one. Judge Johnson allowed live testimony, cross-examination, expert analysis, new mental health evaluations, and detailed presentations from mitigation specialists. It was, for all purposes, a mini trial about the fairness of the original trial. Eaton's lawyers painted a completely different picture of the man the jury had sentenced to die. Severe childhood abuse, lifelong trauma, neurological and cognitive impairment, and a mental health profile that they argued would have profoundly changed how at least one juror saw the case. They argued that this was the evidence the 2004 jury never heard, not because it didn't exist, but because Eaton's trial attorneys never uncovered it. And under Supreme Court precedent, that alone can overturn a death sentence. The Wyoming Attorney General's office countered hard. The original trial had been fair. The evidence of guilt was overwhelming, and the defense was asking the court to second-guess reasonable tactical decisions. But as the hearing went on, the record grew heavier, more detailed, and harder to ignore. The May petition and the July evidentiary hearing were the final turning points, the last pillars of Eaton's federal case, the point where everything crystallized. Because for the first time, all the mental health evidence was on the record. All the missed mitigation was finally illuminated. All the failures of the penalty phase defense were laid bare. And Judge Johnson had the full picture the 2004 jury never did. 11 years after Lisa Kimmell was found in the North Platte River, and 9 years after Eaton was sentenced to die, the foundation of the death sentence had been shaken. What happened next in November of 2014 would change the course of Wyoming capital law. This was the moment the tide turned. This was the beginning of the end of the death sentence. On November 20th, 2014, in a federal courtroom in Cheyenne, the long and punishing legal aftermath of Lisa Marie Kimmell's murder reached its final turning point. A decade after a Natrona County jury sentenced Dale Wayne Eaton to death, and 25 years after Lisa was taken from the side of the highway, a single ruling from U.S. District Judge Alan B. Shithead would reshape everything. The case, Wyoming law, and the future of capital punishment in this state.
Is that his legal name, his given name?
It ought to be.
Nice.
This was the moment when the system finally admitted what Eaton's attorneys had been arguing for years, that the death sentence, as imposed in 2004, was constitutionally unsound. Judge Dipshit's ruling was exhaustive, hundreds of pages detailing every misstep, every omission, every constitutional violation buried inside Eaton's original defense. But at the core of the opinion was a simple truth. Eaton's sentencing phase defense was broken, not legally flawed in some minor procedural way, constitutionally defective. The judge found that Eaton's trial attorneys had failed to investigate and present critical mitigation evidence. I don't give a shit. How do you mitigate murdering a woman and throwing her in the river?
Right.
Is there any mitigation to that? In my mind, there sure as a shit ain't.
And burying your car.
And burying her car. The judge found that they had missed powerful testimony about Eaton's childhood abuse, his cognitive impairments, and the trauma that impacted his psychological development.
Okay.
Again, I don't give a shit.
Question.
Yep.
If he had child abuse, did his siblings have child abuse?
Yeah, I
Were
mean,
they abused?
I see your point.
Did they go kill someone and throw it in a river and bury your car?
Exactly. And what about
No.
everybody else that was abused as a child? I'm not saying that this douchebag had a great childhood. He didn't.
No.
He had a shitty childhood.
No.
But so do a lot of people.
Exactly.
And it does not give you a right to go and kill people. And as far as I'm concerned, I could give a shit whether the jury heard about it or not, because in my mind, it's completely irrelevant.
Right.
It doesn't matter whether your daddy beat the shit out of you or not. It doesn't give you the right to kill somebody.
Exactly. But I also stand firm, and if that's what did it to him, his brothers would have been right alongside him killing people too.
Well, everybody, every single person that had an abusive childhood should then be able to go out and kill people, because that's what it makes you do. So everybody that had a bad childhood, now you have a free pass to go kill people. It's absolute bullshit.
It's insane, yeah.
And the idea that sentences only applied to people that had good childhoods is ludicrous.
Bullshit.
It's ludicrous
Where's that
to me.
button?
Oh, come on now. That ain't even bullshit. That's horse shit.
There we go.
Yeah. I mean, it's absolutely absurd. And then he also found that the failures were not strategic, not excusable, and not within the minimum standards required for a death penalty case. Johnson wrote that these omissions were so severe that they undermined the reliability of the entire sentencing process. And that meant the same thing under federal law as it does in plain English. The jury never heard the truth. With that ruling, Judge Asshat did what no Wyoming court had ever done before. He vacated all 4 of Eaton's death sentences. But this was not freedom. It wasn't even mercy. 3 of Eaton's original sentences, the one tied to aggravated kidnapping and the related violent felonies, still stood. Together, they carried life in prison plus 40 years. Even without the death sentence, Eaton would never walk free again. But the legal distinction mattered to Eaton, to the Kimmell family, and to the state of Wyoming, because for the first time since 2004, Eaton was no longer on death row. Judge Johnson gave the state of Wyoming 120 days to decide whether it wanted to retry the penalty phase, but he also noted, with unusual candor, that the years had taken a toll. Mitigation witnesses had died, memories had faded, records had been lost, and Eaton's mental condition had deteriorated. A new capital sentencing became far more than a legal question. It became a practical impossibility. The judge didn't say it outright. He didn't need to. The writing was on the wall. And as far as I'm concerned, I don't know a thing about this judge other than this case, but in my opinion, this is a judge that allows his own politics and feelings enter into the courtroom, because not only did he say that the original thing was all defunct and you can't kill this guy, but he also said, don't even bother bringing it back again, because there's no way you can ever sentence this asshole to murder or to death because all this other bullshit. It's just, he just doesn't like the death penalty. And I think that they could have walked into this courtroom and said, well, Judge, he stubbed his toe on the way into the court. And he just said, I agree. We absolutely can't kill somebody that stubbed their toe. Anyway, Eaton's resentencing collapse didn't just end one case. It ignited a statewide debate. For legislators, prosecutors, and legal scholars, the ruling became a test case for the viability of the death penalty in Wyoming. The cost? The Eaton case had already consumed millions in trials, appeals, and federal review. Fairness? Decades-long litigation made closure almost unreachable. Error rates? The ruling forced a reckoning with whether the state could administer capital punishment at all. Feasibility? The practical question of whether Wyoming could realistically retry a capital case after so much time. The implications reached far beyond the courtroom. They reached into the heart of how Wyoming viewed justice and whether capital punishments still fit within it. For the Kimmell family, the ruling was devastating, and they're the ones that matter. This piece of shit doesn't matter. This family is what matters. After years of reliving the worst moments of their lives through hearings, appeals, and cross-examinations, the promise of finality, the one thing they had been told the death penalty would deliver, evaporated. Eaton would never be released. He would die in prison. But the symbolic weight of the death sentence, the accountability that it represented, was gone. And once again, the system had asked the Kimmells to endure something no family should ever have to. Not just the loss of their daughter, but the loss of the justice that they had been promised. The ruling on November the 20th, 2014, did more than remove Wyoming's only inmate from death row. It marked the beginning of the end of capital punishment in the state. It forced prosecutors, legislators, and communities to confront what the Kimmell case had laid bare, that the death penalty was not swift, not simple, and not reliable. Not here, not now, and perhaps not ever again. For Lisa's family, the ruling brought a painful kind of permanence. For the state, it brought a reckoning. For Eaton, it brought the end of his time on death row. And for everyone watching, it brought a question Wyoming still struggles with. What does justice look like when the system itself falters? When Judge Dipshit Johnson overturned Dale Wayne Eaton's death sentence in 2014, Wyoming found itself standing at a crossroads, and no one felt that more deeply than the Kimmell family. For them, justice wasn't abstract. Justice had a name, a face, a life stolen. And the death sentence had been the only promise the system ever made. So when the federal court gave the state a choice, retry the penalty phase or accept life without parole, Natrona County did not hesitate. They chose to fight. They chose to pursue death again. And for the next 7 years, Wyoming would chase the possibilities through every legal channel it had left. Just weeks into the new year, prosecutors filed their notice. The state of Wyoming would seek the death penalty again. It was a bold move, a costly move, and in many ways a symbolic move, a declaration that Lisa's life still mattered, that the horrors of March 1988 would not be diluted by the technical failures of Eaton's original defense team and by a dumbass freaking federal judge. But even in 2015, everyone knew the truth. The road ahead would be slow, hard, and full of constitutional landmines. Nothing in capital litigation moves quickly, and for the next several years, the case crawled through federal and state courts, motions, scheduling battles, hearings, and the endless grind of high-stakes appeals. All the while, Eaton was aging, declining, and slipping deeper into the kind of medical deterioration that raises serious questions in death penalty law. But the state pressed on. In July of 2019, the U.S. Court of Appeals for the 10th Circuit issued a major ruling. Eaton's convictions were rock solid. The federal court's 2014 reversal applied only to the sentencing phase, and Wyoming had every right to pursue a new penalty trial. With that ruling, Natrona County District Attorney Dan Inzen reaffirmed the state's intent. They would continue seeking death. For the Kimmell family, it felt like vindication, a sign that the system still recognized the severity of what had been taken from them. But for Eaton, the clock had begun to run out. Eaton's attorneys made one last attempt to block the sentencing. They filed a petition for a writ of certiorari in the U.S. Supreme Court, arguing that the 10th Circuit was wrong, the federal ruling was flawed, and Wyoming should not be allowed to retry the penalty phase. On May the 20th, 2020, the Supreme Court denied the petition without comment. The message was clear. Nothing prevented Wyoming from seeking death again. No more appeals, no more delays, at least not from the federal courts. By late 2020, it's insane to believe, like you mentioned, the COVID.
Yeah.
Well, we're here.
We're here.
It's insane to believe this shit is still going on in 2020. By late 2020, Eaton was 76 years old. He'd suffered multiple strokes. He was experiencing profound cognitive decline, advanced dementia, and erratic psychiatric symptoms. And so the court ordered a full neurological and psychiatric evaluation at the Wyoming State Hospital.
Which we paid for.
Of course we freaking did. We paid for all this shit.
I know.
Because under the Constitution, the death penalty cannot be imposed or even pursued against someone who cannot understand what is happening, assist their attorneys, or comprehend the purpose of a sentencing hearing. That's why you don't wait freaking all this time before you freaking kill them. The stakes suddenly shifted. If Eaton was found incompetent, the death penalty would collapse, not because of mercy, but because the law demanded it. The evaluation report arrived in late August, and it was devastating. Dr. Elizabeth Donegan, along with other specialists, concluded Eaton was not competent. His impairments were permanent, and he was not restorable. Years of strokes had damaged his frontal lobes. Dementia had eroded his executive function. Delusions and confusion had compromised any meaningful ability to understand proceedings. He could not participate in a trial. He could not meaningfully communicate with counsel. He could not comprehend the nature or purpose of a capital sentencing. Legally, ethically, constitutionally, capital prosecution was over. With the competencies findings in hand, Natrona County prosecutors did the only thing that they could do. They withdrew their intent to seek the death penalty. It was not exoneration, it was not forgiveness, and it certainly was not mercy. It was a legal necessity. The Constitution simply does not allow the execution of someone who can no longer understand their punishment. Eaton would spend the rest of his life in prison, under a sentence of life plus 40 years, with no possibility of parole. The effort to reimpose death had lasted 7 years, and it ended not with a jury, not with a verdict, but with a medical diagnosis. The last chapter in the Eaton case was the hardest for Lisa's family. They had watched the system promise justice. They had watched it fall apart. They had watched it try again and again, only to collapse under the weight of time, illness, and legal standards meant to protect the integrity of capital punishment. They were told that Eaton would die for what he did, and then they were told he wouldn't, and then they spent years believing it might still happen, until the final answer arrived, it never would. For Wyoming, this ending raised questions about the feasibility of the death penalty, questions still echoing in legislative halls today. But for Lisa's family, the ending was something deeper, heavier, and far more human. Justice that came too late, punishment that was promised and then taken away, and the painful truth that time, more than any appeal, is what finally saved Dale Wayne Eaton from the death penalty. 34 years after Lisa Marie Kimmell disappeared off a Wyoming highway, and 8 years after Dale Wayne Eaton's death sentence fell apart in federal court, the criminal case that had consumed a generation of grief was finally approaching its legal end. But in early 2022, even at the finish line, the system failed the Kimmell family one more time. On Jenny, are you ready to be really pissed?
Yeah.
Okay, here we go.
I can feel it.
On January 21st, 2022, the Kimmell family drove to Casper for what they believed would be their final day in court, the resentencing hearing that would close the book on the asshat that had murdered their daughter. But the defendant wasn't there. Dale Wayne Eaton was sitting in prison 180 miles away in Torrington because the Wyoming Department of Corrections forgot to transport him. Officials later called it a communications breakdown. But for the Kimmell family, for Sheila, Lisa's mother, it was salt in the deepest wound. The judge offered a video link option. Sheila refused. "I want him here," she said. "This is my last time." And just like that, the hearing collapsed. The family left devastated, humiliated, and exhausted, forced to relive yet again the feeling that the system could not carry Lisa's case without stumbling. News outlets called it a bureaucratic failure. The family called it what it felt like, re-victimization. Absolutely inexcusable. 2 months later, on March 25th, 2022, the sentencing went ahead on the 34th anniversary of the day Lisa vanished. This time, Eaton was brought to court. He entered in a wheelchair, frail, gray, and slumped. The man who once attacked and murdered a vibrant 18-year-old girl was now a shadow of himself, unsteady, impaired, and in the final decline in a long life spent behind concrete and steel. Some victim impact statements from January were read into the record. Others had been rewritten out of sheer frustration, but every one of them carried the same truth. Lisa's absence had reshaped the lives of everyone who loved her forever. Judge Daniel Fortier imposed the most severe non-capital punishment the law allows: life imprisonment without the possibility of parole or commutation for first-degree premeditated murder, an additional 40 to 50 years for felony murder, and 20 to 25 years each for aggravated kidnapping, aggravated robbery, and first-degree sexual assault, some consecutive, some concurrent, all symbolic of one reality: Dale Wayne Eaton will die in prison. The sentence wasn't a compromise. It wasn't mercy. It was the only thing left. The final legal act in a case that had already taken 34 years to reach this courtroom. The courtroom that day carried a strange, heavy atmosphere. Relief, grief, anger, and numbness all twisted together. For the Kimmell family, the ruling brought closure, but not peace. They finally saw Eaton face to face, not as a violent predator who murdered their daughter, but as an elderly, broken man who would never again see freedom, sunlight through chain link, or the world he once preyed upon. But they also felt the weight of the journey, the false endings, the overturned sentence, the legal collapses, the bureaucratic failures, the years of appeals, and the decades of unanswered questions, especially the one that lingers like a shadow. Was Lisa really his only victim? And so, after 34 years, multiple appeals, federal intervention, a vacated death sentence, and a catastrophic series of procedural failures, the case of Dale Wayne Eaton finally reached its legal conclusion. No more appeals, no more hearings, no more chances. Just a man in a wheelchair sentenced to die behind bars, and a family who, after decades of navigating a system that kept reopening their wounds, finally reached the last page of the file, knowing justice had come, but far too slowly and never in the way that they were promised. The resentencing hearing on March 25, 2022, was supposed to be the final punctuation mark on the legal nightmare that had consumed the Kimmell family for more than 3 decades. And in many ways, it was. But before Judge Daniel Fortier imposed the last sentence Dale Wayne Eaton would ever hear, there was one final moment, one last opening for truth, for humanity, for something resembling accountability, and it never came. Lisa's mother, Sheila Kimmell, stepped forward for the final time. Her statement wasn't angry. It wasn't vindictive. It was heartbreak sharpened into clarity, the kind that only 34 years of grief can shape. She spoke about Lisa's life, about the daughter she lost, and about the decades stolen from their family by legal delays, overturned rulings, missed transports, and the long shadow of Eaton's silence. She said something that she has said since the very beginning, back in 2004. Quote, "We would have accepted a life sentence if he had apologized and told the truth about other families he may have hurt. We begged him to come forward and he refused." End quote. That refusal, that stubborn, chilling silence, is what defined the Eaton case just as much as the violence of the crime itself. The Kimmell family reminded the court that they weren't alone in their suffering, because if Dale Wayne Eaton killed Lisa, there was every possibility he hurt others, and he would take those answers to the grave of his own choosing: silence. Eaton himself couldn't speak. Dementia had hollowed out his mind, leaving him unable to understand the world around him, let alone articulate an apology. So his attorney did it for him. Quote, "He wants to say he is sorry," end quote. Those, yeah,
Oh, I believe it.
those words floated into the courtroom, obligatory, thin, weightless. And Sheila, with the strength she had carried for 34 years, rejected it outright. Too little, too late. An apology delivered on behalf of a man who refused to give any family the truth they deserved was no apology at all. It provided no healing, no answers, no closure. The courtroom understood that. So did the judge. So did the community. Everyone except, perhaps, the man sitting silently in the wheelchair, broken not by remorse, but by time. Judge Forgay listened as the Kimmell family spoke, and he acknowledged their pain, not with platitudes, but with the firm reminder that this sentence, while long delayed, was final. Life without parole, no commutation, no release, plus decades of additional consecutive and concurrent sentences that all amounted to the same truth. Dale Wayne Eaton would leave prison only in a coffin. It wasn't the punishment originally promised, but it was the last punishment the law could give. On July 16, 2023, the story of Little Miss reached millions of homes across the country when Forensic Files 2 aired its episode titled Little Miss Murder. For the first time since Eaton's final sentencing, Lisa's case was laid out in full on national television. Lisa's disappearance in 1988, the discovery of her body in the North Platte River, the DNA breakthrough that exposed Eaton as her killer, the 25 years of legal warfare that followed, and the unwavering strength of the Kimmell family. The episode didn't just retell a crime, it memorialized a life. It honored a daughter whose absence could be felt in the same frame, and it showed a national audience what Wyoming already knew. Lisa Marie Kimmell wasn't just a victim. She was a force, a legacy, and a story that had shaped the very laws of the state. Forensic Files 2 reintroduced Lisa to the world, not as a headline, not as a statistic, but as a human being whose family fought for truth longer and harder than most ever have to. By 2023, the legal story was over, but Lisa's wasn't. Her family had survived 34 years of rulings, reversals, hearings, apologies that weren't apologies, and a justice system that stumbled as often as it stood upright. Yet they continued to advocate not for vengeance, but for truth, for the answers Eaton never gave, for the possibility that other families might find the closure they never received. And thanks to their strength, and to the national attention renewed in 2023, Lisa's story continues to echo through Wyoming's courts, its laws, and its conscience. Justice was not perfect. Closure was not possible. But Lisa's legacy endures. By the time Dale Wayne Eaton finally faded out in the legal system, one truth had already crystallized in anyone who followed this case, including us, including investigators, and especially including the families who still don't have answers. No one seriously believes Lisa Marie Kimmell was his only victim. We've spent this season looking at the evidence, the timelines, the geography, the behavior patterns, and the disappearances scattered across Wyoming and Nevada during the exact years Eaton was drifting, hunting, and hiding in plain sight. And while we're not reopening all of that tonight, the picture we've built together is clear enough. Eaton wasn't some one-off murderer who snapped once. He was a predator, an opportunist, a man whose violence didn't start with Lisa, and it didn't end there either. Even law enforcement, on and off the record, has said as much. And the Kimmell family reached that conclusion decades ago, long before DNA ever tied Eaton to the Little Miss case. The tragedy is that Eaton took those answers with him into dementia, into incompetency, and eventually into silence. He never admitted to another crime. He never named a single location. He never acknowledged the trails of missing women and cold cases that intersect with his routes and his life. He chose cowardice over truth. But silence doesn't erase the pattern, and it doesn't erase the family still searching for someone, anyone, who will tell them what happened. We're not done talking about those cases, and the shadow Eaton left behind stretches far beyond the North Platte River. Because if there's anything we've learned in the Rocky Mountain West, it's that monsters rarely stop at one. Long before the courtrooms, the mistrials, the hearings, and the endless appeals, there was a young woman named Lisa Marie Kimmell. A daughter, a sister, a friend, driving toward a future she never got to live. And in the decades since her murder, the case that came to be known as the Little Miss homicide didn't just reshape Wyoming law enforcement, it reshaped an entire state's memory. Lisa's nickname, Little Miss, painted on the license plate she chose for her Honda CRX, became more than a clue. It became a symbol, a rallying cry, a piece of her spirit that the public clung to as the search expanded from Wyoming to Montana to the entire country. People prayed for Little Miss. They searched for Little Miss. And when she was gone, they mourned her as if she belonged to all of us. That nickname now sits on her gravestone, carved in granite in memory, and it sits inside a scholarship created in her honor at Billings Senior High School, making sure her future didn't end with her life. Lisa's mother, Sheila Kimmell, became the force that kept this case alive during the years when law enforcement turnover, jurisdictional friction, and the investigative dead ends threatened to bury the truth. Her book, The Murder of Little Miss, is more than a memoir. It's documentation of what it takes for a family to drag justice forward against the weight of silence. And on July 18, 2005, what would have been Lisa's 36th birthday, the Kimmell family returned to the Manita property where Eaton had assaulted and killed Lisa after winning a $5 million wrongful death judgment and taking ownership of the land. They burned the buildings down, all of them. It was more than symbolic. It was reclaiming ground that had been stained with horror. It was saying, you don't get to own the last chapter. Lisa's case transformed Wyoming law enforcement in ways that few investigations ever have. 14 years after Lisa was murdered, preserved biological evidence, a rape kit, and a single drop of DNA broke the case wide open. That match to Dale Wayne Eaton through CODIS changed everything. After that, Wyoming agencies prioritized evidence preservation, eliminated backlogs, expanded DNA capability, and modernized cold case protocol statewide. Lisa's case became the argument for what science could do when persistence meets preparedness. The massive wave of sightings after Lisa disappeared, nearly all incorrect, led lead investigator Dan Folsom to acknowledge what the public didn't want to hear. Not a lot of faith in eyewitnesses anymore, virtually none. It was this case that pushed Wyoming toward evidence-driven investigation instead of tip-driven desperation. Conflicts between local investigators and federal agents during the early days of the case highlighted a glaring truth. Without cooperation, justice slows to a crawl. The Kimmell case forced agencies to communicate better, share evidence, and keep personal ego far away from forensic reality. It even required high-ranking figures, including then Sheriff Ron Ketchum, to provide blood samples to eliminate themselves as suspects. In Wyoming, the idea that no one is above scrutiny became part of the investigative culture because of this case. Lisa's legacy isn't just forensic, scientific, or procedural. It's human. Her family's persistence taught Wyoming what it looks like when victims' voices stay at the center. Not pushed to the margins, not forgotten between appeals, not sidelined by paperwork. Their advocacy helped shape better victim support policies, renewed case efforts, and a statewide understanding that justice isn't a moment, it's a marathon. For law enforcement, it became a reminder written in permanent ink. Families don't forget, neither should we. The case appeared in Unsolved Mysteries, Cold Case Files, and most recently, Forensic Files 2, which aired Little Miss Murder nationwide on July 16, 2023. That episode didn't just retell the facts, it reintroduced Lisa's warmth, her smile, and her promise to millions who never knew her. It showed the country what Wyoming already knew, that Lisa's story is bigger than a crime. It's a lesson, a warning, and a testament to what can happen when science advances, when families refuse to surrender, and when investigators push past doubt, conflict, and fatigue. More than 3 decades later, the Low Miss case still shapes Wyoming's approach to violent crime. It defined the importance of DNA in cold cases. It reinforced the need for humility in policing. It strengthened victims' rights, and it reminded the state that justice sometimes comes slow, painfully slow, but it can come. Lisa's story didn't end in 1988. It echoes in classrooms, courtrooms, forensic labs, and in every investigator who understands that behind every file is a family fighting to be heard. Her legacy is not the crime that took her life. Her legacy is the change that followed. Justice is never simple in a place like Wyoming. Out here, the land is wide enough to hide the truth. The winters are cold enough to preserve it. And time has a way of wearing everything down except a family's determination. For more than 3 decades, the story of Lisa Marie Kimmell, Lil Miss, wound itself through courtrooms, crime labs, television screens, and the lives of everyone who loved her. Her case survived the collapse of leads, the rise of DNA, the failure of agencies to communicate, and the justice system that struggled to keep up with the truth. And through it all, the Kimmell family stood tall, demanding answers, demanding accountability, demanding that their daughter be remembered as more than a headline. Their persistence didn't just help solve one crime, it reshaped a state. Because of Lisa, Wyoming upgraded its forensic capabilities, rethought its approach to cold cases, and learned the hard way that eyewitnesses fade, but DNA does not. Because of Lisa, investigators learned to cooperate, not compete. Because of Lisa, victims' families found a blueprint for refusing to be ignored. And because of Lisa, a dangerous predator was taken off the streets before he could harm anyone else again. Whether Dale Wayne Eaton was responsible for one death or many, and we've talked about that extensively this season, the truth remains. He will die behind bars, and Wyoming will never again allow a case like this to drift into the shadows. But the legacy of Little Miss is not found in the man who killed her. It's found in the lives she touched, in the warnings her case delivered, in the reforms it pushed forward, and in the way her story still teaches us, even now, what it takes to fight for the forgotten. This arc has been an emotional one for me personally. Lisa's case is the reason that I became obsessed with true crime in the first place, the reason I became interested in cold cases, in forensic science, in the failures and blind spots that cost people their lives, and the reason Rocky Mountain Reckoning exists at all. This was the case that made me want to understand how justice worked, and more importantly, how it fails. And as we close the book on Lisa Marie Kimmell's story, another case awaits just over the horizon, one that begins in heartbreak, suspicion, and a community torn in half. The disappearance of Kathleen Hazel Perringer, another Wyoming mystery, another family without answers, another set of questions that demand the kind of reckoning we've built this show for. So take a breath. Hold on to the lessons Lisa's case has taught us, because when we step into Kathy's story, we're entering a case just as tangled, just as painful, and with just as many shadows. And out here in the West, the shadows don't give up their secrets easily. There are names that stay with you long after the world stops saying them. Some become landmarks in the landscape of justice. Some become warnings, and some become turning points. For me, Lisa Marie Kimmell was all three. I never knew her. I never met her family. I can't pretend to understand the depths of their loss or the years of silence they endured while the rest of the world kept moving. But her case, her story, is the moment I realized how fragile justice is, how deeply a single moment can change everything, and how much one person's life can teach the rest of us long after they're gone. Lisa's kindness, her ambition, the future she was building, All of that was stolen by a man who deserved none of the power that he took. But what he could never take was the impact her story would leave behind. And I need to say this clearly, and with all the respect it deserves. Lisa, your life is the reason I do this. Your case lit the spark that became my obsession with cold cases, forensic truth, and the systems that fail the people they're meant to protect. Every episode I've produced, every case that we've ever revisited, every victim we've tried to honor, it all traces back to you. Dark Dialogue would not exist without you. This entire network, the research, the advocacy, the drive to bring forgotten stories back into the light, grew from the first moment I learned your name and realized how wrong, how broken, how unfair the world can be, and how badly it needs people willing to dig deeper. And I'm sorry for that. I'm sorry that a tragedy had to be the catalyst. I'm sorry that your story came to me the way it did. And I'm sorry that the fire it lit in me came at the cost of your life, a cost no one should ever have to pay. But I hope that what we're doing here matters. I hope that telling your story with honesty, with compassion, and with an unshakable commitment to the truth is a small way to honor you, not just as a victim, but as a person whose life continues to change others, even now. Your mother, your family, your community, they fought for you with a strength most people will never understand. And nothing I say here will ever take away from the fight that they carried for so long. What I offer is something different. The acknowledgement that your story reached someone far outside your circle, someone who never knew you, but was changed by you nonetheless. Lisa, thank you. For the legacy you didn't choose, for the truth your case revealed, for the standard you set in the pursuit of justice, and for being the first voice that pulled me into a world where victims deserve to be seen, remembered, and fought for. You deserved a long life. You deserved safety. You deserved a future. Because you were loved, you were wanted, and you mattered. And you still do, and you always will. This tribute, this entire series, is for you. Lisa Marie Kimmell's story has stayed with us for a long time, not just because of the brutality of what she endured, but because of everything her family fought for in the years that followed. And as we close her case, there's a weight that settles in, a reminder that Wyoming is full of stories that never got the justice hers eventually did. Somewhere out there in Riverton, a family has been waiting 35 years for answers. No convictions, no remains, no forensic break, no closure, just a daughter coming home from school to find her mother gone, and a police file that grew colder with each transfer from one investigator to the next. So next time, we're turning our focus to Kathleen Hazel Barringer, missing since April 17, 1989. A robe left behind, a purse missing, a car still in the driveway, and a disappearance that has haunted Fremont County for more than 3 decades. It's a case that deserves a voice, and we're going to give it one. Before we go, if you're listening on Apple, Spotify, or anywhere else podcasts live, tap that follow button, give us a rating, drop us a review, hit the thumbs up, and share the episode. Every bit of engagement helps keep these stories visible. If you want to support the work we do, the deep dives, the records digging, the case files, the production, you can join us on Patreon, Coffee, and Substack. Every contribution goes back into the show and into honoring the people whose stories we tell.
And if you ever want to connect with us, share a tip, or suggest a case, you can always reach us at info@darkdialogue.com. You can follow us on social, subscribe on your favorite platform, or binge the entire Dark Dialogue network at whatever pace your sanity allows. We appreciate you being here, and we don't take it lightly. You're the reason these cases stay alive.
For Rocky Mountain Reckoning, I'm your host, John.
And I'm Angela.
Stay safe, take care of each other, and make the guilty face the reckoning.